Abrego Garcia is back. Constitutional crisis averted, days saved. It turns out the Trump administration could get him back whenever they wanted and they were just lying through their teeth. Except that it seems, unfortunately, the Trump administration only brought him back to try him on some very serious federal charges.
Abrego Garcia has landed in the United States to face justice. On May 21st, a grand jury in the Middle District of Tennessee returned a sealed indictment charging Abrego Garcia with alien smuggling and conspiracy to commit alien smuggling in violation of Title 8 U.S.C. 1324.
Yes, after months of defying court orders and claiming they just couldn't possibly bring Kilmar back from an Salvadoran torture prison, now the Trump administration is proudly announcing Kilmar's return to U.S. soil so they can pursue human smuggling charges against him. And you know the charges are completely legit because they've rolled out the red carpet, done the media blitz proclaiming that Kilmar is, among other things, a human trafficker, an MS-13 gang member, and even a pedophile now. But this announcement, with its barrage of unproven smears, and we'll talk about that too, comes just in the nick of time for the administration, which was facing potential sanctions in a Maryland civil case filed by Kilmar and his family. Now, as you may recall, Abrego Garcia was born in El Salvador. After being threatened for several years by the Barrio 18 gang, Kilmar fled his home country and joined his brother in Maryland. In 2019, he was picked up in an ICE sting outside of a Hyattsville, Maryland Home Depot. Law enforcement claimed that an informant had identified Kilmar as a member of MS-13, but no actual charges were ever filed, and Kilmar's immigration proceedings resulted not in a deportation, but instead in a withholding of removal order, which, because he had demonstrated a credible fear for his life, barred Kilmar's removal to El Salvador specifically. Now, after his release from immigration detention, Kilmar returned to his life in Maryland, had a child with his wife, helped his wife raise her two other children, and was employed as a sheet metal worker. But on March 12, 2025, Kilmar was driving home with his 5-year-old son when he was pulled over by immigration officers. They arrested him without explanation and threatened to have social services pick up his son if his wife didn't arrive within 10 minutes. Kilmar was then whisked off to ICE detention and, with no due process whatsoever, was sent for an indefinite stay in a torture prison in El Salvador, the very country a judge had expressly forbidden the U.S. government from sending him to. Kilmar's wife, Jennifer, had no idea where he was until someone sent her a picture of the inmates in El Salvador's notorious CICOT prison, and she recognized her husband in the photo. Now, as we've talked about, CICOT has a well-documented history of human rights abuses, including torture, overcrowding, and death at the hands of guards and other inmates. Yet the Trump administration has putatively paid $6 million in a contract that no one has seen yet to El Salvador to house deportees, including many who had never been convicted of any crime, in CICOT under the watchful eye of Bukele, the dictator of El Salvador. Trump and Bukele both bragged about this arrangement on social media, on the news, and in fact, even in the White House.
How can I return him to the United States? Like, I smuggle him into the United States, or what do I do? Of course, I'm not going to do it.
Trump even publicly raised the possibility of sending Americans, homegrowns as he called them, to CICOT.
We also have homegrown criminals that push people into subways, that hit elderly ladies on the back of the head with a baseball bat when they're not looking, that are absolute monsters. I'd like to include them in the group of people to get them out of the country.
And Bukele has seemed excited about the idea of getting paid to violate the rights of American citizens. Meanwhile, Abrego Garcia's wife, Jennifer, filed a suit against the Trump administration. In several court filings, the Trump administration admitted that it had sent Abrego Garcia to El Salvador in error, but the administration still refused to bring Kilmar back. After Maryland federal judge Paula Zenas granted a temporary restraining order directing the Trump administration to, quote, facilitate Kilmar's return, the Trump administration went on the offensive and resurrected a slew of unproven accusations that Abrego Garcia was a member of the MS-13 gang, and even went so far as to Photoshop a picture of Abrego Garcia's hand tattoos with clearly non-original lettering of MS-13. They touted some old restraining orders that his wife had filed against him, and most important here, they unearthed the story of the time he'd been pulled over by law enforcement in Tennessee and questioned because he was driving from Texas to Maryland with several other immigrants, and the administration used that stop to imply that Kilmar was a human trafficker. Now, some of those accusations may be true, but we can't be sure which ones because Kilmar was never tried in court. The government has never had to meet its burden of proof, and no judge or jury has ever considered the evidence and made a finding. The administration's accusations were just that, they were accusations, and without due process, there was no way to evaluate their veracity. But in addition to the PR, the Trump administration also appealed Judge Zenas' order to the Supreme Court, which issued a unanimous decision affirming that the administration had to, quote, facilitate Abrego Garcia's return to the United States. Though oddly, Deputy Chief of Staff Stephen Miller apparently read an entirely different Supreme Court decision and declared this a victory for the White House.
In our favor.
In our favor, against the district court ruling, saying that no district court has the power to compel the foreign policy function of the United States.
And around that same time, Trump and Bukele, who had a meeting at the White House, had jaunty back and forth talking about how they couldn't possibly return Abrego Garcia to the United States.
The question is preposterous. How can I smuggle a terrorist into the United States? I don't have the power to return him to the United States.
But meanwhile, Judge Zenas was growing increasingly weary of these antics and ordered the administration to give regular status updates about what steps it was taking to facilitate Abrego Garcia's return. But the administration did not take this order particularly seriously. The Trump administration filed a series of uninformative so-called status updates, which basically amounted to thumbing their noses at the court. But in response to this recalcitrance, after a contentious hearing, the judge granted the plaintiff's request for expedited discovery. But not surprisingly, the administration immediately appealed, asking for a stay of the judge's discovery order. But the Court of Appeals denied the request for a stay, and the government was left in the uncomfortable position of having to provide Judge Zenas with evidence that it was complying with the law, which it seemed clear they were not. Meanwhile, Maryland Senator Chris Van Hollen paid Abrego Garcia a visit in El Salvador. But after several characteristically anemic status reports, plaintiffs filed a motion claiming that the Trump administration wasn't engaging in discovery in good faith. Defendants objected to plaintiffs' discovery requests, arguing that the timeline for discovery was too fast. The discovery requests were based on the false premise that the United States can or has been ordered to facilitate Abrego Garcia's release from custody in El Salvador, and claiming that the material was privileged. But the judge wasn't having it and took the Trump administration to task for its continued non-compliance, stating that, quote, defendants and their counsel well know that the falsehood lies not in any supposed premise, but in their continued mischaracterization of the Supreme Court's order. Defendants' objection reflects a willful bad faith refusal to comply with discovery obligations. And she found the defendants' privilege claims equally specious and their complaints about the timeline unconvincing because, quote, for weeks defendants have sought refuge behind vague and unsubstantiated assertions of privilege, using them as a shield to obstruct discovery and evade compliance with this court's orders. But she directed plaintiffs to narrow their interrogatories and ordered defendants to actually answer. Now, over the next month, the parties continued to fight over the scope of the discovery and the adequacy of the Trump administration's responses. But because of the administration's continual recalcitrance in this case, including, according to plaintiffs, discovery deficiencies, consistent delays and refusal to reply properly to interrogatories, plaintiffs asked Judge Zenas permission to file a motion for sanctions. And on June 4th, after months of uncooperative behavior, the judge granted the plaintiffs permission to move forward with their motion for sanctions. Now, meanwhile, the Trump administration tried to get the entire lawsuit dismissed, claiming that Judge Zenas and the Maryland District Court lacked jurisdiction. While that motion to dismiss was still pending and plaintiffs were busy drafting their motion for sanctions, the Trump administration made the surprise announcement that, amazingly, Abrego Garcia had been returned to the United States. Now, if you've been renditioned to a foreign country and then inexplicably brought back to the United States only to face federal charges, you're probably going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of the data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So to the surprise of everyone, in a one-page notice filed with the court on June 6th, the Trump administration informed the court that, quote, on April 4th, 2025, this court ordered defendants to facilitate the return of plaintiff Kilmar Armando Abrego Garcia to the United States. Defendants hereby provide notice that they have complied with the court's order and indeed have successfully facilitated Abrego Garcia's return. As the Attorney General recently announced, Abrego Garcia was returned to the United States today to stand trial on criminal charges in the Middle District of Tennessee. So the administration then argued that the judge's order should be dissolved and the entire case should be dismissed as moot. In the meantime, the administration requested a stay on all case proceedings, including discovery. So it turns out that despite the Trump administration's repeated protestations and statements to the court, they actually were capable of bringing Abrego Garcia back. Or as the plaintiffs put it in their June 8th motion asking the court to continue to allow discovery and potential sanctions, quote, two things are now crystal clear. First, the government has always had the ability to return Abrego Garcia, but it simply refused to do so. Second, the government has conducted a determined stalling campaign to stave off contempt sanctions long enough to concoct a politically face-saving exit from its own predicament. And obviously the face-saving exit the plaintiffs are referring to is the Trump administration's decision to bring Abrego Garcia back to the United States, but only after the Department of Justice had indicted him for charges relating to a 2022 traffic stop in Tennessee. So let's talk about that incident. Here's what we know so far. On December 1st, 2022, Abrego Garcia was pulled over for speeding in a vehicle with 8 passengers and told police that he had come from Texas several days earlier and were traveling to Maryland to do construction work. The police officers who stopped him speculated that he might be transporting people for money because there was no luggage in the vehicle, but they decided not to ticket or charge Abrego Garcia. Instead, they sent him on with a warning. And so it's this incident that appears to form the basis of the federal charges that have been filed against Abrego Garcia. And on June 6th, we finally learned what those were when the Trump Department of Justice asked for the unsealing of a shocking May 21st grand jury indictment against Abrego Garcia. So first, a note on grand juries. A grand jury trial is not a regular criminal trial. It is, in most criminal cases, the precursor to a criminal trial, during which the prosecutor presents a group of randomly selected jurors with the prosecutor's potential arguments against a defendant. It's how the charges get formalized. In an actual criminal trial, the defendant would have an attorney, an opportunity to present witnesses and arguments in their defense, and the ability to confront the witnesses against them. But in a grand jury proceeding, the defendant and his attorneys cannot be present to refute or even hear the evidence or witness testimony. And grand juries can also consider evidence like hearsay that would not be admissible in a criminal trial. In a criminal trial, the prosecution must prove beyond reasonable doubt that the defendant is guilty, and in a grand jury trial, the prosecutor must only prove that there is probable cause to believe that a crime has been committed and that the person being investigated was the person who committed it. And obviously, grand juries do not convict people, they simply recommend whether a prosecutor should launch a criminal trial against that person. And grand jury proceedings are not adversarial proceedings where both sides can present evidence. They are one-sided proceedings where only the prosecutor gets to present their case, which is why grand juries have often been criticized as a rubber stamp for prosecutors. But sometimes, as is the case here, a grand jury says there's not even enough evidence for one particular charge or others. And that acts as a sort of veto against the charges even before a case has been filed. And in this previously sealed grand jury indictment, the Department of Justice alleged that Abrego Garcia's 2022 trip through Tennessee was one of more than 100 human trafficking trips that Abrego Garcia made as part of a years-long conspiracy. Now, obviously, anytime we deal with an indictment, these are merely accusations from the government. They are so far unproven. But according to the government's filings in the U.S. District Court for the Middle District of Tennessee, the government alleges from 2016 to 2025, Abrego Garcia conspired with several other unnamed non-citizens to transport thousands of undocumented immigrants from South and Central American countries into the United States. The government alleges that Abrego Garcia's co-conspirators helped the immigrants illegally cross the border into Texas. Then Abrego Garcia and other drivers were paid to transport the undocumented immigrants to other parts of the United States. And according to the indictment, both Abrego Garcia and many of the people he transported were members of the MS-13 gang. The government is also alleging that Abrego Garcia and his co-conspirators transported people, including children, in unsafe ways in makeshift seats and in the floors of vehicles, and that Abrego Garcia himself had abused some of the women he had transported. And the indictment also mentioned that one of Abrego Garcia's supposed co-conspirators was involved in a 2021 incident where a tractor trailer carrying migrants overturned in Mexico and caused more than 50 deaths. And based on these allegations, the government indicted Abrego Garcia on 2 counts from 8 U.S.C. 1324, conspiracy to transport aliens and unlawful transportation of undocumented aliens. The first section creates criminal liability for anyone who, quote, knowing or in reckless disregard of the fact that an alien has come to, entered, or remains in the United States in violation of law, transports or moves or attempts to transport or move such alien within the United States by means of transportation or otherwise in furtherance of such violation of law. So to make its case, the DOJ will have to prove that Abrego Garcia transported or attempted to transport illegal aliens within the United States, and also that he either knew or recklessly disregarded the fact that they were in the United States illegally. Now, in the indictment, the government highlighted the fact that Abrego Garcia supposedly received compensation for this work. As Pam Bondi has claimed, it was his, quote, full-time job. The DOJ is probably emphasizing the financial aspects of the accusations because under the law, if Abrego Garcia was financially compensated for transporting undocumented immigrants, that would allow the prosecution to pursue a stiffer sentence. Now, we don't yet know what evidence the government has in support of these allegations. We'll have to reserve judgment until we see that evidence. But I will say, it is awfully convenient that they've suddenly found all of these horrendous accusations relating to the seemingly random guy that just became the flashpoint for this entire international snafu. Which leads me to be more than a little skeptical about these accusations. Now, the Trump DOJ has also filed a motion for detention, asking the court to hold Abrego Garcia in pretrial custody instead of releasing him on bail pending trial. In support of that argument that Abrego Garcia is a danger to the community and should not be released, the government dropped a few more bombs in both its motion and Attorney General Pam Bondi's announcement, which are not part of the indictment, claiming that Abrego Garcia had also transported firearms and drugs, that he was responsible for the murder of a rival gang member's mother in El Salvador, and that he solicited naked pictures from a minor. But Abrego Garcia has not been indicted on either of those claims, no evidence has been offered to support them, and not even the grand jury considered them. Now, putting aside the salaciousness of these new allegations, it's worth mentioning just how unbelievably improper it is for the sitting attorney general to make these prejudicial statements about a criminal defendant who is actively being prosecuted by the Department of Justice. The Trump administration's campaign to smear Abrego Garcia in the media is itself a breach of norms and potentially prosecutorial ethics. In the past, federal, state, and local prosecutors from both political parties have generally only publicly accused defendants of crimes for which a grand jury indicted them. Discussing other potential crimes has long been regarded as an abuse of prosecutorial power, risking obvious unfair harm to defendants' reputations. And according to NBC News, a former senior Justice Department official who requested anonymity citing fears of retaliation said that Bondi often speaks as a partisan Trump loyalist, not as a neutral law enforcement officer. Yeah, dude, we have TVs and eyes. We can see it. But additionally, according to an ABC News report, concerns about the Trump administration's behavior in the Abrego Garcia case may have led to the resignation of Ben Schrader, the chief of the criminal division of the U.S. Attorney's Office in Nashville. Sources briefed on Schrader's decision told ABC News that Schrader's resignation was prompted by concerns that the case against Abrego Garcia was being pursued for political reasons. Mr. Schrader did not directly address the speculation, but in a pointed LinkedIn post, he stated, quote, "Earlier today, after nearly 15 years as an assistant U.S. attorney, I resigned as chief of the criminal division at the U.S. Attorney's Office for the Middle District of Tennessee. It has been an incredible privilege to serve as a prosecutor with the Department of Justice, where the only job description I've ever known is to do the right thing in the right way for the right reasons." So yet again, a career prosecutor with the DOJ resigned rather than move forward with these criminal charges. So I think at this point we can move from being skeptical about the government's charges against Abrego Garcia to just assuming that they're BS. But still, at least this time he's getting due process. A jury will decide whether the charges against him actually stand up in a criminal court. But already there appeared to be some factual disputes in the government's findings, including inconsistent statements about whether Abrego Garcia told Tennessee police that he was coming from Missouri or Texas. None of these supposed witnesses mentioned in the indictment are named. Many of them appear to be convicted criminals who may have had incentives to be jailhouse informants. And an ABC News report indicates that one of the informants is currently serving a sentence in Alabama for illegally re-entering the United States. All of these factors will have to be considered by an actual jury, and all these witnesses will have to be available for cross-examination and scrutiny. Though, as Abrego Garcia's attorney has pointed out, this still isn't true justice because, quote, "True justice means the chance to defend yourself before you're punished, not after." Meanwhile, President Trump has claimed that he thinks the administration has, quote, "a very easy case against Abrego Garcia," which sort of raises the question, if it was so easy, why not prosecute him earlier instead of making the politically controversial and unconstitutional decision to whisk him off to a torture prison without due process? And for the time being, the case before Judge Zenas is still alive. The plaintiffs have asked the judge to continue to hold on to her jurisdiction over the case, to order discovery against the Trump administration, and to consider their motion for sanctions. And regardless of the outcome of Abrego Garcia's criminal trial and civil case, the constitutional problems still remain because dozens of other men are still being held in the Salvadoran torture prison without trial or recourse. As Representative Jamie Raskin pointed out, quote, "They obviously want to make this about whether or not he ends up being a good guy or a bad guy, but it's not a moral question. It's a legal question. It's a constitutional question of whether the government can pick people up and take them out of the country." So yeah, that's why it's probably a good idea to scrub as much of your personal information off the internet as possible, which you can do with today's sponsor, Incogni. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. And you can use my link in the description or the code LegalEagle for an exclusive 60% off discount. And Incogni just launched a new feature called Custom Removals for subscribers to their unlimited plan that I think is really great. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people's search sites. Because these data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many scam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take weeks. So thanks Incogni for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the data broker removes your data once, they can collect it again. So Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word, at checkout. So after that, click on this link over here for more LegalEagle, or I'll see you in court.